All rise. The Honorables, the presiding judge, judges of the North Carolina Court of Appeals. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning. Welcome to the Court of Appeals. Your panel this morning, I'm Judge Donna Stroud. To my right, we have Judge Jeff Carpenter. On my left, Judge Carolyn Thompson. And we have one case for argument today. It looks like y'all are in place and ready to go. And if you wanted to reserve time for rebuttal, did y'all already get that set up?
Yes, sir.
Okay, very good. Then we are ready to proceed.
Thank you, Your Honor, and may it please the court. My name is Brandon Mays, and I represent the appellant, Mr. Barton. I plan to address the sentencing issue first, and then address the satellite-based monitoring order. Your Honors, the sentencing issue in this case is simple, although it may deal with an issue of first impression. A plain reading of NC Gen Stat Section 15A, 1368.5 requires supervised release to run concurrently to a period of probation a defendant is subject to during the same period. The only exception in the statute is if the jurisdiction who imposed the probationary sentence does not allow for concurrent periods of supervision. North Carolina, the only sentencing jurisdiction in this case, not only allows concurrent periods of supervision, but requires them. The state argues that 1368.5 does not apply in this case to the probationary judgment because Mr. Barton was not subject to probation because probation did not commence until after the period of supervised release. The state is wrong, and this case centers on what subject to means in this context. This court has already explained what subject to means in this context in State v. Kennedy. There, this court, interpreting NC Gen Stat 15A, 1346A, held that a defendant was subject to a probationary sentence, even though that sentence did not commence until the completion of another probationary sentence. And if you look at the two statutes, 1346 and 1368.5, use strikingly similar language requiring probation and post-release supervision to run concurrently with other sentences. If the state's logic was correct, then this court would have ruled consecutive probationary sentences permissible under 1346A in Kennedy. But that is neither what the statutes say nor what this court said. By the statute's plain language, Mr. Barton is subject to the contingent probation, and he was subject to it the day the trial court entered it. And 1368.5 requires his period of post-release supervision to run concurrently with his period of probation. This court should remand the probationary judgments for resentencing as it did in Kennedy.
What the judgments appear to reflect what you're asking us to do already.
Well, Your Honor, I think
I've examined the judgments, and I don't see anywhere in the judgments that it's set forth that probation runs at the expiration of post-release supervision.
I think you're right if you look at the judgment, just the judgments itself, Your Honor. I think if you look, it says at the expiration of the sentence. The other option is release from incarceration, which is specifically what Mr. Barton is asking for. I think there is case law that says that the supervised release portion of an active sentence counts as part of that sentence, so the trial court marking at the expiration of the sentence means that, although the judgment doesn't say that expressly. But if you look at the transcript on pages 16 and 17, that's exactly what the trial court meant, and it said so itself, because defense counsel made a point of clarification saying, you know, Your Honor, I just want to make sure you're talking about 5 years of supervised release followed by 5 years of probation. Then the court says, yes, 10. It's not, you know, that's what he wants, that's what the trial court wanted, was 10 years of supervision. So where it doesn't say that expressly on the judgment, the trial court made clear that's what it wanted to do.
But, of course, we're controlled by what the judgment says. no matter if the judge might say something on the bench, but the written judgment controls, so.
Yes, Your Honor.
Does the written
That's
judgment
correct. If there
still
was
mean that?
unless there was a difference that wasn't material to the judgment itself. I think the judgments, the probation judgments in this case, and in seemingly all now, probation judgments make that sort of unclear, at least in this context. Kennedy addressed a similar issue. It was just two allegedly consecutive periods of probation, and the trial court marked the same box. And this court said, no, the statute says there's only one way you can run probation consecutively to another sentence, and that's an active sentence. So you see
I suspect that your opposing counsel is going to say this case is different than Kennedy because this is post-release supervision and probation, two different things that we're talking about.
Sure, Your Honor. And Mr. Barton doesn't need 1346 and Kennedy sort of on their own to support his argument. 1368.5 says it clearly. It says that periods of post-release supervision run concurrently with any federal, state, prison, jail, probation, parole terms to which the prisoner is subject during the period. This court has said that basically same language in the consecutive probation context means that a defendant is subject to that contingent period of probation, even though it does not commence, as the state argues, until after the supervised release period. And I'll read it again, to read this, if you read 1346, a period of probation commences the day it is imposed, runs concurrently with any other period of probation, parole, or imprisonment to which the defendant is subject during this period. It's basically the same language. And we've said in Kennedy that means you can't stack two probations. 1368.5 says clearly you can't stack probation and post-release supervision. And accordingly, Mr. Barton asked this court to remand the probationary judgments for resentencing as it did in Kennedy. Turning to the satellite-based monitoring order, the state presented no evidence other than the static 99R during the SBM hearing. The trial court could not have made additional findings to support its ultimate finding. Mr. Barton needed the highest level of supervision because the state presented no additional relevant evidence at the hearing. This court should reverse the SBM order. As this court has held in MAC, NC Gen Stat 1420840A requires a separate SBM hearing. The statute has two phases. First, it requires the district attorney to initiate SBM proceedings and to present evidence of eligibility. The statute requires the defendant to be allowed to rebut the state's evidence. Then, once the trial court has established eligibility, it moves to the second phase where it can consider the static 99R and any relevant evidence relating to the highest level of supervision. Here, the state presented no evidence. In fact, transcript page 18, when the trial court asked the state, "Do you wish to be heard on SBM?" the state said, "No, sir." Then the trial court went into its findings, imposed SBM, asked the state again on transcript page 20 if it had anything to add, and the state said no. The state argues that the factual basis for the plea presented at the criminal plea hearing were evidence the trial court could have considered, and that argument runs headlong into this court's opinion in MAC. In MAC, the trial court heard evidence supporting findings of recidivism during sentencing, but the state expressed that it wished to address SBM at a later hearing. The trial court entered an order anyway. This court vacated that order because there was no evidence presented during a separate SBM hearing. There simply was no hearing. If the trial court in MAC could have considered evidence prior to the SBM hearing without the state presenting that evidence again at an SBM hearing, there would have been no need to disturb that order. But here there was a hearing and the state did not present any evidence.
I want to ask you a question about what you believe the standard of review is on the SBM issue. Trial judge is not required to place a defendant on SBM, is that correct?
That's correct, Your Honor.
To exercise of discretion.
Well, I think the standard of review is whether the trial court, the evidence supports the trial court's findings that support its ultimate conclusions. That
So that if the trial court makes findings, then it must, is what you're saying. It's not an exercise of discretion.
if it makes findings that the defendant requires the highest level of supervision, and that finding has to be supported by the evidence. And here, Your Honors, the state's cases that it cites to support its argument that the trial court could have considered the factual bases from the plea hearing don't actually support its argument. In Blankenship, the factual bases were presented again at the SPM hearing, which would have been permissible. In Gross was a bring-back hearing, I think 10 plus years after the original sentencing. And so that information or that evidence was presented during the SPM hearing. In Green, although the trial court completed the eligibility phase of the SPM hearing during sentencing, the trial court continued the case for 21 months so that the parties could gather additional information, and the defendant admitted to one of the facts during the SPM hearing after continuation. And the remedy here is reversal, because the state simply refused to present evidence during the SPM hearing. Thus, as this court held in Jones and Kilby, there was no other evidence on which the trial court could base an SPM order, and the state does not get a second bite at SPM. And if there are no more questions, I'll reserve the remainder of my time for rebuttal.
Okay.
Good morning, Your Honors. May it please the court. My name is Joe Finarelli. I'm here from the Attorney General's office on behalf of the state. Like Mr. Mays, I will start with the sentencing issue and begin, I think, first by taking issue, Judge Carpenter, with your belief that I think the judgment does not indicate that the probationary period was to begin at the end of the active sentence that was imposed originally. On page 27 of the record is the judgment suspending sentence. This is the first of the three suspension, I'll just call them the suspension judgments. And it indicates there, if you go down to the suspension of sentence section, it's ordering supervised probation for 60 months. But it checks box 3 that says this period of probation shall begin, and it doesn't check when the defendant is released from incarceration. It checks the box at the expiration of the sentence. So the key point, I think, of this judgment is it is indicating that the trial judge, not only what he said in the transcript, but the judgment itself indicates he was intending to impose a consecutive term of probation at the expiration of the active sentence.
What's the authority for that? What empowers the court to do that? How do you reconcile that with 15A 1368.5?
Okay. 1368.5 says that it's the language is subject to. I think opposing counsel pointed that out, that was the crux of its statutory interpretation argument. If the probationary period is not one that Mr. Barton was subject to while he's serving his term of post-release supervision, then it doesn't run concurrently. So he's not completed, the probation doesn't commence. We can go back to the 1346, 15A 1346, which talks about when probation commences. Ordinarily, probation would commence when it's imposed. That's the default rule in subsection A. Subsection B, however, it also says in subsection A, except as provided in subsection B, that default rule applies. So if you go to subsection B, that provides for the running concurrently a probationary sentence to an active sentence of imprisonment. If you interpret 15A 1368.5 differently, you are eliminating the ability to run I think what you're doing is you're eviscerating the ability to run consecutive terms where a probationary sentence follows the completion of the sentence that's imposed with the active term of imprisonment. It's not, if the defendant is not subject to that probationary period at the time the post-release supervision starts, then 15A 1368.5 doesn't apply. Now, if you find that they're subject to it from the moment it's imposed, whether it commences the moment they're imposed, as 1346A would suggest, or whether it's subject to it because in the future there's a term of probation that they would ultimately pose, we'll lose. But my argument is they are not subject to a term of probation at the time he is serving, Mr. Barton is serving a period of post-release supervision. If he violates the terms of post-release supervision, I think this is a real-world way of trying to explain how, practically speaking, this is not what the legislature intended. If Mr. Barton is serving a period, he's released from custody before the completion of his maximum term of imprisonment. He's on post-release supervision. He violates the term of post-release supervision. He goes back to prison, but so you're counting then the probationary period. You're giving him credit for a probationary sentence that hasn't started yet for the period of time that he's on post-release supervision, however long that is. It's at least 5 years, and if he violates at any point in that 5 years, he goes back to serve the remainder of his sentence. So you're giving him credit for serving the probationary sentence while he's on post-release supervision, and then when he goes back to serve the sentence that was the trigger for the probationary sentence in the first place. It'd be one thing if Mr. Barton was already subject to and serving a term of probation, violated the terms of probation by committing a criminal offense. That criminal offense is a sexual offense or whatever offense that requires some period of post-release supervision. And he is then released from the active term, still on post-release supervision. At that point, the probationary period he was serving before the new conviction and this post-release supervision he's serving for the new conviction can run concurrently. He's already subject to the probationary sentence because he was serving the probation when he violated it. Here, that's not what Mr. Barton is doing. Mr. Barton has not served his sentence. He has not served a period of post-release supervision. And so 15A 1368.5, unless you read is subject to mean may ever in the future serve a period of probation, then I think you have to respect the decision of the trial court to run it consecutively, because it would be permitted in the context of the probationary example as well. Kennedy does not say that an offender is subject to a period of probation while they're serving an active sentence. That isn't what Kennedy holds. That isn't the issue in Kennedy. Kennedy was addressing when the judgment that imposed the contingent judgment, the probationary period after the active term, when the judge doesn't specify when that term of probation is supposed to start, you go to the default rule in 1346A. It runs from the time it's imposed, and so therefore you cannot stack the terms of probation that were imposed in that case. You have to run them concurrently at the same time. It doesn't say that he wasn't subject to probation. It says that he's not subject to 2 terms of 36 months of probation. And I think that's what the Kusar, I think I'm pronouncing that correctly, Kusar case that we cite in our brief, clarifies. Kennedy's talking about 2 consecutive periods of probation. Kusar says if you're talking about suspended sentences, that's different. Kennedy doesn't control that situation. And Kusar continued that because the judge there didn't specify when the period of probation was supposed to begin, you have to again go to the default rule and they run concurrently. Everybody, I think all of this court's decisions have concluded the default rule applies unless there's an express intention in the judgment from the trial court to run them consecutively. And if you do, you can run that term of probation consecutive to an active sentence. Now, none of the cases that I've found, certainly none of the cases that Mr. Mays found, address this precise question, where there's a period of post-release supervision and what effect that has when a contingent probation judgment is imposed. For the reasons I've gone through, I don't believe, and the state does not believe, that 15A 1368.5 is invoked here because Mr. Barton was not subject to a term of probation at the time he's serving his post-release supervision period. He's still subject to the active sentence that if he violates the terms of the post-release supervision, he will go back and serve the conclusion to the maximum term. So if you are going to conclude that 1368.5 and the is subject to language applies to consecutive sentences that are properly imposed under 1346 or under Kennedy or Kusar or any of the other cases that talk about probation following an active term, if you're going to say that 1368.5 precludes that structure simply because there's a period of post-release supervision that must be served before that probation even starts, then again, we lose on that point. I think it really comes down to that question. What do you interpret the is subject to language to mean in 1368.5? But I certainly wanted to start with the idea that the judgment does say, and each of the other judges, we're not talking about whether the judge could stack the probationary periods that are imposed after this one. That's not the issue here. If Mr. Barton completes post-release supervision, begins 60 months of probation, he's going to serve one 60-month period of probation. The cases say you can't stack the probationary periods then. They're designed to be consecutive if those sentences are activated, not if he is serving a term of probation. But that's not the issue that you're being asked to address here.
Interestingly, on the probationary judgment,
Yes.
under the suspension of sentence section, paragraph 1 is about the longer sentence. It has a statutory reference. Paragraph 2 is about not delegating. It has a statutory reference. Paragraph 3 is about the longer period being able to run at the extension, but there's no statutory reference there. Wonder why?
You're talking about in the suspension of sentence section?
Yep.
Is that what you're saying?
Wonder why? My guess is because there's not a statute.
Well, no, I would agree. There's not a clear statute that answers this question. I suspect if there was, our position would be different, and I'm not sure you would have taken this case.
So the AOC created this. The AOC created the form, and your position is, since the judge checked the box that the AOC created on the form, it's now the law.
No, what I'm saying is the law doesn't prohibit what the judge did here. I agree with you, there is no statute that expressly authorizes in one self-contained provision that the judge can run this probationary term consecutive to a period of post-release supervision. But there is no statute that says that they can't either. And I think that's what we're arguing about, and that's the decision you get to make.
We can agree that probation is completely statutory.
Correct.
There is no common law probation. It's all statutory.
Yes, I would agree.
So if the statutes don't say you can, your position is, doesn't have to run through the legislature anymore. The AOC and the judge can do it. We can make the law at the courthouse and over in Cary at AOC. It doesn't have to go to Jones Street anymore.
Well, no, I'm not, I don't know that I'm reaching that far, Your Honor, to say that they can create law. They are interpreting, and I think the judge mentioned in the transcript, this is the way he has treated this issue and has sentenced individuals like this. This is the first instance I'm aware of. I don't know that our office is aware of another situation where this kind of sentencing structure has been done. I'm here to defend the sentence, and I believe that defense is predicated on the fact that it's not precluded by the statute, and I think is consistent with what the legislature said in 1368.5.
And I appreciate the fact that you're here to defend it. And surely you didn't think you were going to come over here and not have to answer some hard questions.
Oh, no,
on
no,
an issue of first
I enjoy that aspect of it, Your Honor, I actually do. I think, unless the court has other questions about the sentencing issue, I'll turn briefly to the satellite-based monitoring issue. Clearly, the state presented no evidence at the hearing when given the opportunity to do so.
They presented a static 99. That's,
Well, you're right. They had handed up the static 99, I think technically before they had actually turned to what I would call, and I think what from my experience handling these cases, what is typically when the SBM hearing starts. Usually, sentence, plea colloquy, sentence imposed, okay, let's talk about satellite-based monitoring. There was a static 99 handed up, and there certainly was a factual basis for the plea that was provided by the assistant district attorney. That factual basis included a discussion that the minor victim, the young girl who was depicted performing oral and vaginal intercourse with an adult male, was 6 to 8 years old at the time that the offenses were committed. The judge heard that factual basis, included that finding when he was imposing satellite-based monitoring, and believed that that finding or that fact was sufficient to overcome the average score on the static 99 that was handed up, and concluded that the defendant required the highest possible level of supervision and monitoring. Aside from those two facts, the static 99 and the age of the victim, the state agrees. There was no presentation made by any of the parties, including the state, which had the obligation ordinarily to do so. The question here, I think, is not, well, if you believe that that's not sufficient. And this court's case law has been varied, I would say, over what it will return to the trial court for a new hearing and what it will reverse and not remand. So there's a little bit of interplay. I don't think there's any clear case that was cited by either side, because I think we're both taking issue with the cases we've each cited in our respective briefs, that isn't really applicable. However, remand here is appropriate because this court has found in some cases that where there is evidence that would support or could, if properly determined, could support the imposition of satellite-based monitoring, then you send it back to the trial court to do it again. Now, one point that I would make with respect to my opponent's argument, it appears to me that they have in a way, they're switching horses on appeal. Now, in their reply brief, just working backwards, in their reply brief and in the argument this morning, counsel was presenting to you the State v. Mack case as an instance where you should remand, even though Mack actually remanded, not reversed. They cite to Mack for the proposition that it's instructive on whether this hearing was appropriate, and that you should then depart from Mack and reverse but not remand. Mack was a case where the trial court did not conduct any hearing at all. The state requested and indicated to the court that it intended to conduct the SBM aspects of the process at a subsequent hearing. The court went ahead anyway and issued an order imposing satellite-based monitoring. And what this court said in Mack is, that isn't even a proper hearing. It wasn't about the sufficiency of the evidence. It wasn't about the fact that the state presented no evidence. It was the judge didn't have jurisdiction to even make the order because he or she had not conducted the satellite-based monitoring hearing that the statute requires. Now, that's different from the argument that the defendant made in their proposed issues in the record on appeal. In the proposed record on appeal, the issue was that the trial court erred where the only evidence considered was defendant's static 99 score. Then in their brief, it was whether the trial court's finding was supported by the record. Now Mack is, well, there's no evidence at all, and therefore you should reverse. So I'll address them in turn. I've already discussed the Mack case. It's not applicable. And even if it were, the Mack court, the panel in Mack, reversed and remanded for the conduction of a proper SBM hearing. It didn't say, well, there's no evidence before us, and so because the state put on no evidence, this case is over, state gets no second bite at the apple.
What's the purpose of a satellite-based monitoring hearing? Well, let me help you. What I think the purpose is. It's due process, right? Because it's an imposition of state authority, so you need due process in order for that to happen.
There are certainly due process components to it, yes, sir.
Your position is that the whole trial was sort of the due process, and the judge doesn't go deaf or blind after the trial is over and comes forth with knowledge that was presented in the evidence at trial, correct?
Yes, and I think the case law from this court suggests that the judge in that circumstance can either take evidence that's heard at trial or in a plea colloquy, a factual basis for the plea, that the trial court can use those facts to support an SBM determination. Now, normally it's done with an additional findings form and there's more to a hearing than what was done here. But the evidence that was presented here through the factual basis about the age of the victim is a piece of evidence that sometimes in conjunction with other facts, sometimes not, this court has said this can be sufficient or could be sufficient to impose satellite-based monitoring. But if we're not sure and there needs to be more facts or there are certain facts that the trial court considered that weren't appropriate, we'll send it back and have them do it again.
Well, the age of the victim wasn't an element of the charge for the plea, was it? I mean, I don't know.
No, it was not an element of the charge, I guess, other than it was sexual exploitation of a minor.
But just the fact that the person is a minor is the relevant fact for purposes of...
Right. No, I think the element issue would be if this were a finding that were an aggravated offense, you would need to make sure that the elements of the offense
I remember, and I can't remember the name of the case. I know there was one where, because obviously a lot of the time in plea agreements, the allegations that have been made against the defendant would have supported a far more serious charge if all of those things were proven beyond a reasonable doubt. And then, there's a lesser sentence that's agreed to, but oftentimes the factual basis includes things that we'll say, higher than obviously the offense that's being actually pled to. And I believe there's a case that addresses that, you know, if it's something that's beyond, that it would maybe need more than that, or maybe I'm not remembering that correctly.
Yeah, I'm not sure I recall that case in particular, but certainly, I mean, I think from my experience, and the court can reach its own conclusion, the colloquy here was simpler than most.
Yeah.
I mean, there was
Right.
digital images transmitted, they got a warrant, they got his phone, the images were on his phone, he's
Right.
pleading guilty. And the minor was 6 to 8 years old, and there were this many images on the phone. There were certain charges that were dismissed as part of the plea. He pled guilty to these 4, and now we're off. And that's where we're at. So, you know, the state's position is remand, have the proper SBM hearing. If you find that it's not, we understand that the only other remedy for this court would be simple reversal and no imposition of SBM. But there is evidence in the record that the state concludes would support a determination that despite the average score for Mr. Barton on the static 99, that there would be enough if the trial court went and made findings of fact and the state presented evidence based on the plea colloquy or anything else that would support the imposition of a satellite-based monitoring order. Unless the court has other questions, I think I will leave the rest of my time to my opposing counsel.
All right. You may proceed.
Thank you, Your Honor. And I'll start my rebuttal with the sentencing issue. I think even if the trial court was trying to run consecutive sentences and we're just looking at the judgment, 1368.5 simply says that you can't do that. I think if the General Assembly wanted this court and everyone else to treat the two, 1346 and 1368.5 differently, they would have used different language in those statutes, but they didn't. They used almost exactly the same language. As far as the sort of hypothetical scenario of a defendant getting credit when their supervised release, when they violate the terms of their supervised release and go back to an active sentence and they're still getting credit for this contingent probation, I think the same factual scenario could apply to consecutive periods of probation that 1346 says you cannot sentence a defendant to. And I take issue, I think Kennedy expressly says that you cannot, no matter what the trial court marks on a judgment, you cannot run consecutive periods of probation based on this, almost exactly the same language. And on page 459 to 460, after listing 1346 A and B, the court says, a careful reading of the statute shows that any sentence of probation must run concurrently with any other probation sentences imposed on a defendant. And then further down it continues that the trial court could not impose a period of probation to run consecutively with another probation period. That language is clear. They're saying you cannot run 2 consecutive probationary periods because the defendant is subject to that contingent probationary period.
Post-release supervision and probation are under different sections of the statute, though.
They are, yes,
They're
Your
not
Honor.
the same.
That's right, Your Honor. And like you said, probation is a statutory creature, but so is post-release supervision.
For all practical purposes, they are the same, but they appear in the law in 2 different places.
Correct. They're very similar. Probation has more to it just because of the nature of it, but if you look at the statutory structure, they're very similar, and that's for good reason. They're both periods of supervision. And in Kennedy, we said you can't run 2 periods of supervision consecutively, and the same language is used in 1368.5.
Your colleague says that the applicable statutes don't say the judge couldn't do it.
I think it absolutely does, Your Honor. Just looking at the statute, it says post-release supervision, periods of post-release supervision run concurrently with any other probationary term. That's while they didn't use shall, it sounds a lot like shall to me. And the only exception, it says only if the jurisdiction that imposed probation does not permit concurrent supervision. So notwithstanding that exception, post-release supervision runs concurrently with any other state or federal jail, probation, or parole terms.
Do you believe that a judge has discretion to separate the post-release supervision and probation and run them consecutive to one another?
No. I think 1368.5 removes the discretion to structure a sentence like that. And this court addressed that sort of issue in Kennedy. The court said, we understand what the trial court was trying to do. It was trying to, in its discretion, impose a sentence that might be more protective of the general public. But the same language in 1346 just simply prohibited the state or the trial court from doing that. And the same logic applies here, Your Honor. Turning to SBM, and we mentioned the finding of the victim's age. The trial court made two findings, really, if you look at the transcript. The finding of the victim's age and also that the defendant posed a danger to minors. However, if you look at the record on page 39 and the AOC Form 16, the trial court was merely reciting findings 7 and 8 on page 39 that says the defendant presents or may present a danger to minors under the age of 18. The victim was, fill in, 6 to 8 years of age at the time of commission of the present offense. Both of those findings include a note that says this finding relates only to possible future prosecution under two statutes that deal with sex offender unlawfully on the premises and a ban on conduct that endangers children. It does not apply to registration or SBM in this case. So to the extent the trial court was making that finding, its own 615 form says that it doesn't apply to SBM in this case. And while I may have sort of misspoke as to no evidence was presented, the static 99R was presented, Your Honor, but no evidence related to whether he required the highest level of supervision was presented. There may be evidence in the record, as my colleague says, but it was not presented at the SBM hearing. And SBM is a civil regime that is separate from the criminal regime. And I think if you look, while they're not the same statute, the bring back hearing statute, 40B, if you were having a bring back hearing, how could you go from he's eligible to really nothing without bringing back the evidence from whether he pled, the plea agreement, or whether it was the evidence that was adduced at trial? So I think Mack was not an attempt to switch horses. Mack was an attempt to show that when nothing is presented to the trial court, there's nothing that can, at the SBM hearing, there's nothing that can support an SBM order. Now, my colleague is correct that Mack is different and that this court held there was no hearing. And so they vacated and remanded for an appropriate hearing. However, that's because the state lost its opportunity to pursue SBM. The state said, yes, we want to pursue SBM. We're just going to do it later. And the trial court usurped their ability to do that, to get evidence, appropriate evidence on the record that would have supported, even on appeal, an SBM order. Here, the trial court expressly asked the state if it wished to be heard, and it said no, and it did not present any evidence other than the static 99R. So the state shouldn't get a second chance at SBM. And as this court held in Jones and Kilby, there was no other evidence presented during the SBM hearing on which the trial court could base an SBM order. And Your Honors, if there are no further questions, I'll conclude. NC Gen Stat Section 15A 1368.5 requires periods of supervised release to run concurrently to a period of probation to which a defendant is subject. Mr. Barton was subject to the probation judgment the moment the trial court rendered it. The state did not present evidence supporting any of the trial court's findings during the SBM hearing. Thus, the SBM order was devoid of findings supporting the imposition of SBM. Mr. Barton respectfully requests this court remand the probation judgments for resentencing and reverse the SBM order. Thank you.
Thank you very much for your arguments, and we will adjourn.
All rise. Court adjourned.
Just brought me back to law school. It's like statutory
Yeah.
interpretation.
Good job. I appreciate it.
He interned in my office years ago. So
Okay.
Yeah, he helped raise me a little.